According to court documents and publicly released records, the story does not begin with rumors or speculation. It begins with pages, hundreds of pages, many of them heavily redacted, with black lines cutting through sentences like shadows across a photograph. And yet, even with those redactions, something remains visible. A structure, a pattern, a network of movements, flights, meetings, legal negotiations, and sealed agreements that investigators, journalists, and the public have tried to understand for years. This is where the documents begin to feel unsettling. Because when pages are released, but large portions are hidden, the question is not only what is written, the question becomes what is missing and why. According to public records and filings connected to the case of Jeffrey Epstein, a number of documents were gradually released through court proceedings, civil lawsuits, and requests for transparency. Some are connected to testimony given under oath. Others reference financial records, travel logs, and communications cited during legal disputes. But an important legal principle must be stated clearly. Being mentioned in documents does not imply wrongdoing. Many names appear in legal records simply because they were referenced during investigations, depositions, or administrative records. Even with that legal clarity in mind, the scale of the documentation raises serious questions about how such a network of records accumulated over time. According to court filings, the timeline stretches across years, touching multiple jurisdictions, private aircraft logs, financial transactions, and settlements negotiated through legal channels. And this is where the story quietly changes. Because what the files reveal most clearly is not a dramatic moment. They reveal a slow accumulation of decisions, legal strategies, negotiated outcomes, institutional responses, with processes unfolding gradually inside systems that rarely operate in public view. But this is where the documents start to become interesting. Many of the released records do not read like accusations. They read like fragments, pieces of testimony, scheduling notes, references to meetings, descriptions of flights, mentions of locations, all appearing within legal filings that were never originally written as a narrative for the public. Yet when these fragments are placed side by side, something else begins to appear. Do you want to know the truth behind the Epstein case? The darkest, most shocking secrets that the powerful don't want you to know? Then you need to follow this channel right now. Click the subscribe button and turn on the notification bell, because what we're about to reveal will shake the very foundations of power, and you can't miss a single detail. Prepare yourself for a journey into the depths of depravity and corruption, and join us in this fight for justice. Subscribe now. According to records available in court archives, Epstein maintained multiple properties in different locations. Those locations appear repeatedly across various filings, sometimes in deposition transcripts, sometimes in logistical references, sometimes in travel-related documentation. Again, appearing in a document does not establish guilt, but patterns within records can reveal structures, and structures are what investigators attempt to understand. This is where another layer begins to emerge. According to publicly reported records, A plea agreement reached in 2008 became one of the most debated legal developments in the case. The agreement resolved certain charges at the time, but also raised questions among legal analysts regarding its scope and long-term implications. Over the years, journalists, attorneys, and legal scholars examined that agreement closely. They asked how such negotiations occur, who participates in them, and how institutional decisions shape their outcomes. Because legal outcomes rarely happen in isolation. They emerge through discussions between prosecutors, defense attorneys, and courts operating within specific jurisdictions. And this is where another detail becomes visible inside the documents. Many of the records connected to Epstein were not released immediately. Instead, they appeared gradually through litigation, appeals, and court orders, sometimes years after the events referenced inside them. Each release created a new wave of public attention, not always because the document contained shocking revelations, but because every newly unsealed page added another piece to a record that already felt incomplete. This slowly changed the central question. Instead of asking only what happened, observers began asking how institutions responded, how investigations unfolded, how evidence was documented, how settlements were negotiated, how records were sealed, and under what circumstances they later became public. According to court archives, numerous civil lawsuits included testimony describing interactions, travel arrangements, and workplace environments. Again, these references appear as allegations described within legal filings. Allegations referenced in filings do not equal confirmed conclusions unless proven in court. But even within those boundaries, the accumulation of testimony gradually forms a timeline that investigators, journalists, and researchers continue to examine. And the first thing many of them notice are the redactions. Entire sections blacked out, names removed, sentences interrupted in the middle, paragraphs partially hidden behind thick black bars. Redactions are not random. They follow legal rules. They may protect identities, preserve ongoing investigations, or prevent the release of sensitive personal information. But they also create something else, absence. An absence that becomes almost as visible as the text itself. When readers encounter those blacked out lines, curiosity naturally grows, but responsible investigation does something different. It focuses on what can actually be verified, what appears clearly in the record, what is confirmed by filings, and what remains unresolved. And this is where another documented detail appears. According to flight logs referenced in filings and widely reported by investigative journalists, private aviation played a central logistical role in the movements described within the case. These logs appear not as narrative, but as administrative data. Dates, routes, passenger references, locations. Again, appearing in a travel log does not imply wrongdoing. It only indicates that an individual was recorded on a specific flight. But patterns still matter, because patterns reveal scale. And the scale visible in these records raised additional questions about oversight, about regulation, about how complex networks of travel, property ownership, and financial activity can operate across multiple jurisdictions at the same time. This is where the files begin to feel heavier. because the documents do not provide a single explanation. Instead, they reveal overlapping systems, law enforcement agencies, prosecutors, civil courts, financial institutions, aviation records, and property registries. When systems intersect like this, responsibility becomes harder to trace, and this is where the investigation becomes more complicated. The public often searches for a single moment when everything could have changed, but the documents rarely show such moments. Instead, they reveal gradual processes, negotiations, filings, delays, appeals, settlements unfolding over many years. This changes the nature of the question entirely. Why? Because instead of asking how one case unfolded, observers begin asking something larger. How do institutions respond when wealth, influence, and jurisdiction intersect within the same legal timeline? That question appears quietly throughout the files themselves, even when parts of those files remain hidden behind redactions, and perhaps that is the most unsettling detail within the entire record. Not what the pages clearly say, but what the blacked out spaces suggest about the parts of the story the public has never fully seen. Because when investigators began comparing testimony, travel records, and sealed agreements across multiple filings, something unexpected started to appear. At first, the records looked isolated, but when placed side by side, they began to outline something larger, something the released pages only begin to hint at. And this is where the next layer of the Epstein Files begins to emerge. This is where the documents begin to reveal something more complex. When investigators and journalists started placing different records side by side, the timeline slowly expanded across many years. According to publicly available court filings, deposition transcripts, and legal archives, certain details appear repeatedly in separate proceedings, not as accusations, but as references, mentions within testimony, descriptions of locations, travel arrangements, and administrative records connected to meetings or schedules. It is important to repeat a legal principle here. Appearing in a document does not imply wrongdoing. Many individuals are mentioned in records simply because they were referenced during testimony, logistics, or communication records presented during legal proceedings. But what caught the attention of researchers was not a single name or event. It was the recurring structure of the documents. Different filings created years apart as sometimes referenced similar locations, similar timelines, and similar institutional responses. According to public records, many of the most detailed documents came from civil litigation. In those cases, depositions were conducted under oath, producing extensive transcripts. Thousands of pages of testimony were recorded long before many of those documents became public. Years later, courts began ordering portions of these transcripts to be unsealed. When those pages appeared, our researchers noticed something unusual. Some sections were readable, others were heavily redacted. Entire names removed, sentences partially covered, paragraphs blacked out. Redactions follow legal rules. They may protect privacy, ongoing legal matters, or individuals who were never charged with a crime. But they also create gaps in the narrative. And those gaps make the visible text feel incomplete. This is where the conversation slowly shifts, because the files begin raising questions not only about the case itself, but about transparency inside legal systems. Courts must balance two competing principles: public interest and legal protection of individuals. That balance determines what becomes public and what remains sealed. Over the years, several waves of documents were released through court decisions. Each release added more pieces to a record that was already complicated. And each time, the same pattern appeared again. Administrative records, travel logs, deposition excerpts, legal motions, financial references. Individually, they seem ordinary, but together, they begin to outline a much larger structure. And this is where investigators began asking a deeper question. If the released pages already span thousands of documents across multiple legal systems, how much of the full record still remains sealed inside court archives? Not through a single dramatic revelation, but through the timeline that emerges when the known events are placed in order. According to public records and official filings, the legal history surrounding Jeffrey Epstein unfolded over many years and across several investigations, lawsuits, and court proceedings. In 2008, Epstein reached a plea agreement in Florida related to state charges. That agreement resolved the case at that time and later became the subject of intense public debate among legal analysts and journalists. Many question how the agreement was negotiated and how the legal system handled the case during that period. Over the following years, civil lawsuits continued to appear in court records. These cases included depositions and testimony given under oath, producing thousands of pages of transcripts that would later become central to public analysis. Years later, new federal investigations reopened scrutiny of the case. According to official records from the United States Department of Justice, Epstein was arrested in July 2019 on federal charges related to sex trafficking allegations. The charges were based on investigative work conducted by federal prosecutors and law enforcement agencies. The case immediately attracted global attention, and many journalists began revisiting older court documents and previously sealed records connected to earlier proceedings. However, before the case could proceed to trial, Epstein died in federal custody in August 2019 at the Metropolitan Correctional Center in New York. Authorities ruled the death a suicide after investigations conducted by federal officials. The circumstances surrounding his detention later led to internal reviews and public criticism regarding procedures and oversight within the facility. Because the criminal trial never occurred, much of the public record surrounding the case comes from documents rather than courtroom testimony presented during a trial. Civil litigation, depositions, and previously sealed filings therefore became the primary sources researchers and journalists relied on to reconstruct the timeline. Over time, courts ordered the release of additional documents connected to these earlier proceedings. Some records were unsealed gradually through legal motions filed by media organizations requesting greater transparency. Each new batch of documents provided more context about travel records, financial structures, property ownership, and testimony referenced in lawsuits. Once again, courts consistently emphasized an important legal principle. Being mentioned in a document does not imply guilt or involvement in criminal activity. Individuals may appear in records simply because they were referenced during testimony, mentioned in administrative documents, or connected to travel or logistical records. Even with those limitations, the files revealed something significant. The case extended far beyond a single criminal proceeding. It involved civil litigation, financial networks, international travel, legal settlements, and complex jurisdictional issues across different legal systems. This is why the Epstein Files continue to attract attention years after the events themselves. The documents reveal how legal systems operate when cases involve wealth, influence, international movement, and overlapping jurisdictions. But they also reveal something incomplete. Many documents remain partially redacted. Others remain sealed under court orders. Some records exist within institutions that release information only under strict legal procedures. As a result, the public archive surrounding the case is both extensive and unfinished at the same time. Thousands of pages exist, yet portions remain hidden behind legal protections and privacy rules. And that leads to the final question left by the documents themselves. If so much of the Epstein case became visible only after years of court-ordered disclosures, how much of the full institutional record may still remain sealed inside legal archives? Page after page of legal documents, depositions, travel records, financial filings, and court motions. Some lines perfectly visible, others erased beneath heavy black redactions. The archive exists, but it is incomplete. According to publicly released court materials, thousands of pages connected to the case have circulated through federal courts, civil lawsuits, and investigative reporting over the years. These records show how the story moved through different phases of the legal system: investigations, negotiations, settlements, renewed scrutiny, document releases ordered long after the original events occurred. But the files also show something else. They show how slowly institutional records move. Many of the documents that shape public understanding were not released when the events first happened. Some appeared years later through litigation. Others surfaced only after media organizations petitioned courts to unseal them. Judges then weighed competing concerns: transparency for the public versus privacy protections and legal safeguards. That process is deliberate, careful, procedural, and slow. Because of that, the Epstein archive did not emerge as one complete story. It appeared piece by piece. A deposition transcript here, a flight log there, a sealed motion becoming public years later. Each release changed the timeline slightly. Each document added another fragment. According to public records, and the case crossed multiple legal systems: state prosecutors, federal investigators, civil courts, financial registries, international travel documentation, property ownership records, aviation logs. Each institution documented only a part of the story. No single archive holds the entire picture. Are you shocked by what we've uncovered so far? Well, that's just the tip of the iceberg. There's so much more to come. More powerful names, more sinister schemes, more silenced victims. Yes, if you want to be on the front lines of this investigation, you need to subscribe to this channel now. Leave your comment below and tell us what you think. Your voice is crucial in this fight. The more we unite, the stronger our call for accountability will be. So subscribe, comment, and share. The truth depends on it. This is what makes the files feel unsettling to many observers. Not necessarily what is written inside them, but how the information is distributed across systems that rarely share a unified record. Legal systems are designed to process individual cases. They are not designed to produce perfect narratives for public understanding. Evidence enters the system in pieces. Records are sealed for legal reasons. Agreements are negotiated privately. Documents are released only when courts determine it is appropriate. The result is an archive that feels both massive and incomplete. Researchers studying the documents often notice the same visual detail first: the redactions. Thick black lines covering names, entire paragraphs removed, sections hidden for legal reasons. Redactions are part of responsible legal procedure. They protect individuals who were never charged with crimes. They protect privacy. They protect ongoing legal matters. But they also leave a visible absence on the page. An absence invites questions. This is why the Epstein Files continue to circulate in public discussion. Not because every answer is inside them, but because the documents reveal how large and complicated the institutional process surrounding the case actually became. What the archive ultimately shows is not a single shocking secret. It shows the architecture of a modern legal system handling an extremely complex case across multiple jurisdictions and years of litigation. The files show negotiations between prosecutors and defense attorneys. They show civil litigation moving through courts. They show investigative work group by journalists. They show institutions slowly releasing records over time. All of it documented, all of it partial. And perhaps that is the most dramatic truth contained within the Epstein Files. Not that everything is hidden, but that the story exists as a scattered record across thousands of pages, institutions, and legal decisions. Some pages public, some pages redacted, and some pages that the public may never see. Which leaves one final question quietly hanging over the entire archive. You've made it this far. You've seen how deep the rabbit hole goes, how vast the webs of complicity are. Now you have a choice. You can turn your back and pretend none of this happened, or you can join us. Subscribe to this channel, hit the like button, leave your comment, and most importantly, share this video, because the only way to defeat the darkness is to bring it into the light. The more people see, the harder it will be for the predators to hide. Together, we can build an unstoppable movement for justice. But it starts with you, with your voice, your dedication, your click on that subscribe button. Let's make this echo in the halls of power. Let's shake the foundations of the mighty. Let's show the entire world what truth can do. But only if you join us now. Subscribe. Act. And let's change history together.